Hello, everyone. Welcome to Court with Krissy and Linda. I'm betting this is the first time that you've seen someone wearing a chef hat in court. We've got an emergency TRO hearing with a written ruling. And since someone seems to always flake out and go off in the comments when this happens, I always let you know when there's a written ruling. I brought Linda for backup. Now listen, there's a written ruling. But if I were the judge, I wouldn't be kicking this cook out of his kitchen. I think you might agree. Maybe not. You'll have to let me know. We hope you like it. Court with Krissy and Linda is meow in session.
I have that this was of course not intended to be ex parte, and given all the indicia I have that the party's attorney is planning to appear, that they have an attorney, I'm inclined to wait a bit and
That's
see
fine,
if
Judge.
someone does appear. Not forever, but maybe 10 minutes or so until we hear back from the flake firm. And so if you guys will just sit tight, I'm going to wait and hear back from the flake firm and see if it is their intention to appear today, or if we get any word from them. Okay.
That's no, we have no objection to that, Judge.
Okay.
But yeah, I don't, I always try to extend the courtesy I expect from other attorneys. So, I've run 10 minutes late for a court hearing too. So I
I
understand.
appreciate that, Mr.
Oh,
Oh, look, there's Mr. Flake. Mr. Flake, you're muted. There we go.
Good morning, Your Honor.
Good morning. We were just discussing that I was like, well, I'm going to wait a few minutes because, this wasn't intended to be an ex parte hearing, and Mr. Flake had filed some documents indicating he planned to appear. And Mr. Gerner, to his credit, was indicating he didn't object because we've all been a few minutes late to a hearing before. So I think that's a good foot to start off on of civility and professionalism, and I appreciate it. So.
Yes, I appreciate that. And it will surprise you to know I was copying and pasting passwords and logins, pulling up the notice. So,
I have had that happen to me as well. So in any event, since we are all here, let me start by saying this. So I've received the Jarvis Williams Social Express Catering and Meal Prep versus UH Senior Partnership and the Integral Group, case number 25CV013100. It appears to me the plaintiff, my record indicates, filed this petition for injunctive relief on August the 19th, and accompanied that petition with a motion for restraining order. And then we issued a notice of hearing. Mr. Flake, you, I think, have appeared in front of me before, so you may be familiar with that process. But what I typically do, and what it is the practice generally of Fulton County, is that rather than going forward with an ex parte hearing that will only hold for a very short period of time, and then we have to do it all over again, hey, go make every effort to notify the defendants, which Mr. Gerner did. You obviously got notice. And so what I have also had the opportunity to read in advance of this morning's hearing is an affidavit filed by Watchtower Security that Mr. Flake filed on behalf of his clients. So here's what I think I understand about this dispute. Mr. Williams individually operates some, I'm assuming, some sort of food business inside of a space that is some sort of quasi-residential space. That's about all I understand from what's been filed. And that Mr. Williams has paid rent, and at least in the pleadings that I've seen, there's been no allegation of any non-payment of rent or other issues, but that sometime in, I guess, late August or maybe early August, I'm not exactly sure which, sometime in August, Mr. Williams had some sort of interaction with a resident of the facility, and as that I think I understand was not reported to police. And as a result of that, the property took some action. I'm not exactly sure what the procedural action was in terms of what it was, but took some action to prohibit Mr. Williams from being on the property. And my general understanding from the complaint is that Mr. Williams is not only the principal in name of the LLC, but is the guy that's doing everything. Like, it's his company. And he's saying that the contract, the lease agreement, I guess, to operate a business in that space is being interfered with by Mr. Williams being prohibited from being on the property. So that's what I think I understand. If I'm not complete or if I've said anything wrong, Mr. Gerner, you're the one seeking relief. So tell me what I've said wrong or what else I need to know, and let's take it from there.
Yes, Judge. So it was reported to
Your
the
Honor,
police.
I don't mean to interrupt, but may I pose a question?
Yes.
My understanding of the posture that we're in, and Your Honor did a remarkably good job in a short time of summarizing what I think the plaintiff's view is. I would just ask that Your Honor apply the judicial skill of reserving any judgment until you hear the other side, which I think you'll find is dramatically different as a matter of fact. But my understanding of where we are is that while it's not a true ex parte hearing, we are operating on an emergency basis for a TRO hearing, meaning that the court is called upon to decide whether there are specific facts indicating an urgent and immediate irreparable harm. So, in other words, I have still had very limited time to prepare. I haven't had time to prepare papers. We're going to ask Your Honor to deny this. We think it's due to be denied, but to the extent that the plaintiffs want to persist in this effort to seek injunctive relief, then we, of course, would ask that this be noticed for an actual interlocutory injunctive relief hearing, in which case then the court would have a more fulsome record, would have briefing, and would look at the legal issues in the case, which is an important aspect of it because there's some major issues about the fundamental merit of a number of these cases. So, in brief, I just wanted to make sure that the court's understanding was the same, was that we're here operating under that, under that TRO standard, that heightened standard.
You are correct, Mr. Flake. And I should say before I throw it over to Mr. Gerner, given your very recent entry into the case, Mr. Flake, have y'all had a chance to discuss whether there is anything that can be worked out among the parties? Because oftentimes these TRO hearings, once everybody gets together, the parties, especially in my experience in a business context, are able to resolve those issues. Have y'all had a chance to talk, and do you think that me sending y'all to a breakout room to have a conversation would merit any fruit, Mr. Gerner?
We haven't had an opportunity to talk. I'm more than willing to. I find in civil cases, a lot of times when counsel can get in a room together, we can get things worked out. So if Mr. Flake has no objection, I would be fine with going to a breakout room to discuss for a couple of moments.
Mr. Flake, what are your thoughts?
I am happy to discuss. In fact, I'd be delighted to discuss a resolution of this with Mr. Gerner. I would say this, though, Your Honor, and it goes to part of what I'll share on this motion. More than a month ago, Mr. Williams agreed to resolve this issue. From our perspective, agreed to these restrictions and agreed to move out. And I'll show Your Honor that email that indicates a clear written acknowledgement of that. So,
okay. Well, let me interrupt you for a moment, Mr. Flake. I apologize because I do have a criminal calendar that starts at 9:30, and so I need to be efficient with my time. And it feels
understood.
like, given your respective positions, even if you are able to work it out, I think it may be best for us to go forward today. So we're going to forge ahead and ask Mr. Gerner to go ahead with his presentation. Again, the reason that I started out with a recitation of the facts is just to try and help you understand that you don't necessarily need to educate me about at least the minimal facts that y'all have pled so far, and take it from there so that you can be as efficient with your time as possible, Mr. Gerner, in terms of focusing on why it is an emergency and why immediate relief is necessary now.
Yes, Judge. Your recitation of the facts for the most part correct. The police were contacted. The police did do an investigation. They initially issued their own Atlanta police criminal trespass notice against Mr. Williams. That has since been withdrawn by the police department. The captain of the police department is actually has updated the police reports to because I guess she felt like her officers were did the incorrect thing, and in my understanding, basically escorted Mr. Williams back onto the property. The only reason that this is an emergency at this point is there is a trespass notice that has been issued by Integral to Mr. Williams, who is the principal. And I would note for you that there's a lot of case law that says the landlord has no right to forbid a person to go upon the premises in the possession of a tenant by the latter's permission and for a lawful purpose. That's 322 Georgia App 316. And that's a quote that goes back some time. Your Honor.
Certainly, but I would imagine that what's unique about this circumstance is that in order to access the space that he has leased, he has to walk through and access common areas that involve interacting with other residents against whom, at least right now, Integral has argued he need to be protected from Mr. Williams.
Yeah, Your Honor. The way the layout is essentially there's a back loading dock that Mr. Williams uses. He goes into the building and then gets on an elevator, and it basically takes him directly to his kitchen. Like you did point out, he is the principal. He runs this business. This is his business. He has one or two employees. He has a large city contract serving food to after-school children through the city that he would lose if he's not able to perform every day. That contract is if he was to lose and not have access to the building, he would lose access to that contract, and it's caused him his business irreparable harm. I think, and the emergency is anytime he might go onto this property, he's facing threat of arrest, which can also impact his contract. So I think between those two things, we're entitled to a temporary restraining order, and then of course to come back to argue more permanently for an injunction at some point in the future.
Okay. Before I hear from Mr. Flake, what about his representation that at some point, well, actually, I have a couple of questions. So I'm not sure I understand what this space is. Like, is it because obviously I'm hearing the word resident, so I'm assuming that these are people who live in this space, but also Mr. Williams is operating a business, and those two things happening in the same space aren't that common.
Yes, Judge. So it was an assisted living facility
Okay.
and then it was converted over into independent living. So Integral no longer needed the commercial kitchen because they no
I
longer
see.
serve meals to the residents.
Okay.
So the kitchen within it is from when it was an assisted living facility, and Mr. Williams now uses it as basically a ghost kitchen where he prepares meals and then takes them out to deliver to the community. He has a
Oh,
contract
interesting.
with APS,
Okay.
things like that. And I apologize. What was your second question? I'm sorry.
No, I
Uh,
think that was it.
yeah.
It was just because it was odd for me I needed to reconcile the resident plus commercial kitchen, and now I
Yeah.
understand. Okay. Thank you, Mr.
Um,
Garner. And and then my second question, the second question I had was, what of Mr. Flake's representation? I'm sure I'll hear more about it in just a moment. That there had been some discussion so clearly your petition asserts, and I've gone back and looked at it now when I was saying I wasn't sure, that this incident happened in early August. And there was, I don't know what, because these are just pleadings at this point, but clearly there was some negotiation and discussion between Mr. Williams and Integral about his lease, because there was a discussion of the fact that the deposit he had paid would constitute rent through November.
yeah.
And that you have alleged, and so I'm assuming Mr. Flake is going to say that as part of that negotiation, Mr. Williams agreed to leave the space, although I don't know when or how, presumably when his lease ran out. Can you update me on
Yeah.
your understanding of that, Mr. Garner?
So if it's the email I have seen, the email said he would attempt to leave if he could find another commercial kitchen space that would meet the needs of his business. When you open, I've learned a lot the last couple of weeks about opening a kitchen. There's a lot of steps you have to go to. You got to get it inspected. It has to be cleaned and everything else. He said if he could find a place to go to, then he would put in his 90 days or whatever notice to terminate the lease. I mean, it's a 3-year lease. With an option to do 3 more years that was just started in February. So he said he would attempt to leave if he was able to find a space, but he never made that he never gave them the written notice, I am leaving, if that makes sense.
Okay. And then I will also note, Mr. Flake that the affidavit that he submitted was an affidavit from a security company that certified that there's some link that I am not able to access right now because I'm just looking at a PDF with a link address spelled out. But there is some link that this altercation with the resident that resulted in the criminal trespass warrant was recorded. Were you aware of that, Mr. Garner? And have you had a chance to view that recording?
I reviewed the recording. I think from what my clients have told me, and then viewing the recording, I think there's parts of the altercation that were not caught by the recording. There was an elevator. Our position is that the resident was the aggressor, and that there was an altercation. I will freely admit to that, but that the resident was the aggressor, and that Mr. Williams was protecting his wife from a resident that placed his hands on his wife first.
Understood. Okay. Understanding that is your motion, so I'm going to let you have the last word. Anything else you want to add for now before I turn it over to Mr. Flake?
No, Judge.
Okay. Thank you, Mr. Garner. Mr. Flake? You're muted, Mr. Flake. Wouldn't be a Zoom hearing if I didn't have to say that at least one time.
But believe me, I know one would think. Recognizing that the court has a 9:30 hearing, I will get to the critical piece, which Your Honor identified, and that is, as a property owner and a landlord, there is a duty to keep premises safe and secure. And the landlord, based on an incident that I'll review with Your Honor, made a determination as to an individual, not as to the business, that there is a threat to safety and security on the premises. There's no emergency. There's no urgency. And to the contrary, as I mentioned, there's been an agreement that, and it was a bargain for exchange after this restriction was put in place, that rent would be applied in a certain manner, that Mr. Williams or the business actually would look for a new location, and then would provide notice. I think the most important thing I can do, and I suspected that we have a short amount of time, so I was able to put some slides together that highlight some stills and then the actual material sequence, which just occurred over about 2 minutes in the space, is show that for Your Honor. And there's no sound. So I will do my best to keep it to under 10 minutes and walk through that. But I really want to get to that video. So let me attempt to share. If Your Honor can see here.
Yes, I can see.
Okay. This is the facility. It is a multi-resident facility. These are seniors who live here. And as Mr. Garner mentioned, these are, it's independent living for seniors, but there was a commercial kitchen initially. And so that space I'm going to show you an overview here, is inside the resident on the first floor. There's a kitchen there. It adjoins rooms. It's near the lobby and the activity area. And so if you can see this L shape here, the footage we're going to be looking at occurred at this end of the L. This is an aerial of what you just saw. There's a basement area, which is the access that we'll see going up to the first floor. You just saw that layout where the kitchen is.
Is that the access that Mr. Garner described probably, which is where he's accessing it from a loading dock or something in the basement and taking an elevator to the kitchen?
There are two of them. You see elevator here, and these are camera numbers for the footage that you'll see.
Yes,
there's an entrance there that goes toward the elevator, and there's a stairwell. There's a stairwell here.
Okay.
Now, all we hear about the incident is just what you heard. An incident occurred, passive voice. Mr. Williams acted in lawful defense of his wife. And then in the papers, there's an allusion to use of force. And of course, as Your Honor well knows, force is only justified if there's an imminent threat of force. And it's not justified if one is the aggressor or one provokes it. Now, when you watch this video, you're going to see multiple instances in which Mr. Williams and his wife not only provoke, but escalate the situation. It started when the resident, about 2:05 p.m., tried to get into the elevator. On the basement level, this elevator is coded for use by the social express business, by the tenant. But it is an elevator that goes to all residential floors. And this resident, this older gentleman, wanted to use the elevator. And whether he was ornery or not, whether he was right about going in through the basement or not, what happened to him under no circumstances, when one watching what occurred, was in any way justified. So you'll see, and remember, ask the question, does Mr. Williams' wife appear to be threatened? And who appears to be using force or provoking? You'll see at one point, Mr. Williams' wife running after the resident. You'll see Mr. Williams trapping the resident in the stairwell. You'll see Mr. Williams shoving him once. You'll see him laying hands on him a second time, making physical contact. You'll see him grab the resident by the neck, choking him. And then later, enraged and apparently unable to control himself, you'll see Mr. Williams grab whatever object is in his way and attempt to strike the resident, apparently stopped only by his wife, who's holding her hands up, and by a nearby resident. Now, here's the elevator space on the basement level. Here's a bystander letting the resident in who's wearing a gray hoodie. Can Your Honor hear me?
I can.
And you'll see this is the raw footage that's in the record. I've only added in a larger font which camera we're looking at. So you can see this is camera 6, and you can see a continuous time sequence here. So we have a second bystander and Mr. Williams' wife coming in. Here's the basement elevator. Blocking his way, he goes around. It's a double-sided door, so he's going right around to the other side. Now, if you watch closely, you'll see her gesturing, and it appears making contact with him several times in the elevator. Maybe grabbing and pulling him by the hoodie, but it's not clear at this point. She's calling Mr. Williams. Now it's 2:05. There's the contact. And here he is, pulled in, exiting. And remember, this is being viewed by a landlord and property owner that's responsible for the security of dozens of senior residents. Now, he goes out to the other basement exit Your Honor saw, which is the stairwell. Cut away. Mr. Williams is running down to the stairwell. Mrs. Williams is not apparently feeling in danger because she's running to confront the resident again. Now here's the resident looking a little frenetic. He's caught in the stairwell. At this point, only after he's been struck and choked does he reach in his pocket and pull out what appears to be a penknife or a pocket knife. Now, here we could have walked away again. Now, the full video is here. We'll send a copy to the court. Opposing counsel, the footage is already in the record, Your Honor. But
I do have one question factually. Who is the young man with twists that's in the video?
Seems to be a bystander. He came in initially. He's watching as with the older resident. I don't know for sure, but I would suspect those are residents. So the right to use the premises, it ends when there's a violation of law. It ends when the landlord's rights are implicated. It ends when the landlord's duties are impacted to keep the premises secure. No one watching that and then reading this complaint can come away with the idea that there's been, at a minimum, a fundamental and material omission about what happened. But putting that aside, really what the court's being asked to do is issue a mandatory injunction to put Mr. Williams back in amongst residents. And as Your Honor knows, at this point, the landlord's on notice of violent proclivities. We can't take the risk with a single resident, let alone this one, provoking Mr. Williams again. Premises liability says that landlords has modified and triggered duties when it's on notice of a threat. This was not a light decision. And after discussions with Mr. Williams, after issuing the restriction, let me share one more time very quickly. There was an agreement. I'll put the email and send it into the record, but there was an agreement after the restriction. This is the property management company's email. We're offering you the option to terminate your lease without penalty. Remember, the landlord could have proceeded against the business, but the business is still operating, is still serving food, is still serving customers. This was asked to Mr. Williams individually. This will give you flexibility to secure new space without immediate time pressure as long as you notify us 60 days. Mr. Williams, okay, I'd like the last 3 months of payment. This was his security deposit that was paid up front to go toward the remaining time I'm here, starting with August, as opposed to a refund at the end. I need all the collateral I have in order to move. Can we agree on this as well? No objection. Okay. That's part and parcel of an agreement under which he would not come back into space individually after this notice for the safety of residents. He would be allowed, without the landlord invoking what he would owe on the rest of the lease or declaring lease against this company, to go and secure new space. And that was more than a month ago. And we're hearing that there's an emergency. If Mr. Williams, as he apparently intends to do, tries to come onto the premises again, it will and should be the integral entity who's coming to Your Honor to seek an injunction. That until these issues can be sorted out, until the court can weigh in as we think it should on the fact that this lease has been modified and that these claims don't have merit, and he cannot come into the space. If anyone should be seeking an injunction, it should be integral. So as a TRO matter, we ask that this be denied, and I'll talk to Mr. Gerner, and I, again, welcome the opportunity to try to resolve this. But if the plaintiffs want to persist in moving forward, then we will ask the opportunity to file papers, to put a more fulsome affidavit in from integral and other evidence as necessary, have a hearing and have this completely denied so that there's no possibility looming of Mr. Williams coming back onto the premises.
Thank you, Mr. Flake. I have one question before I throw it over to Mr. Gerner for rebuttal. The emails that you were showing me very briefly, while, I understand you're pointing to the discussion of acknowledgement, it seems like, of some indication of intention to leave and negotiating how the rent will be paid. It looked like some of the discussion was, as long as you give us 60 days notice. Is your position that the agreement in that email where Mr. Williams is negotiating constitutes that 60-day notice?
Is that a question for
Yes,
Mr.
sir.
Gerner?
No, that was for you, Mr. Flake.
It looks like to me, and I'll send Your Honor the full email, and this is also what I understand from my conversations with my client, that that if the business without Mr. Williams, in theory, if it wanted to continue in the space without his presence, I don't think anything in the email says this is the 60-day notice or necessarily that we're leaving. That was my read on it. But
okay, and so that was really my question, is that if Mr. Williams were if Social Express Catering were going to vacate, your client's position is, although there was discussion about 60-day notice, because that's what the email said, as long as you give us written notice of 60 days, that notice hasn't yet been given. And so Social Express continues to have control of the property, and it is only Mr. Williams that's being excluded from the property. That's your client's position, correct?
That's correct. Continues to have the limited use rights under the lease, which is actually a usufruct, but that's a different question. That's correct. Social Express.
Oh my Lord, Mr. Flake, are you trying to make me have flashbacks to law school? I really don't think I've heard the word usufruct since law school.
It's a good word for cocktail conversation, but
Indeed
that
it
is. That is our view, that if we haven't received the notice, that Social Express still has its rights under the lease agreement.
Understood. Thank you, Mr. Flake. Mr. Garner, your response, sir.
A few things. One, that door, there was part of the incident occurred outside of that door that's not in view of the camera. That door actually has a lock on it that has a
You mean the door from outside to inside?
Correct, inside. There's parts of the incident we're not seeing there. That door actually has a lock on it that is a biometric lock that's only supposed to be used by Social Express Catering. It's a fingerprint lock. That's
well,
specific.
Except that apparently residents from the inside can go and open the door to let people in.
Correct.
Which is true about every limited entry door ever, including the one at my kid's high school. So, you know.
They have been told to not let residents use that door. So his wife was trying to enforce a rule that they have been told you're not to let residents come in and out of this door. And so she would not open it up for him while she was out there talking to a vendor. That resident then called that older woman to come down and let him in violation of the rules and regulations that Social Express Catering has been communicated by Integral. That resident came down he called that resident. He said, I'll come get in that door. Called that resident to come let him in. And he started.
Forgive me for interrupting, Mr. Garner.
Yeah.
Question. Do you know who the young man is with twists that's in the picture?
I do
Because
not.
I mean, when I first saw it, I thought, oh, maybe he's an employee of Social Express Catering or something.
I do.
Now, he's not a resident.
Okay.
He was accompanying the older gentleman.
Okay,
Mr.
so
Brown.
he's just someone associated with one of the residents. Okay, thank
correct.
you, Mr. Williams. Go ahead, Mr. Garner.
And my understanding is that the resident started cussing at Mr. Williams' wife, started threatening her, and then we see what happens on the security camera. Essentially, the security camera does not give the full picture. And then also integral to the credits, acknowledging that the resident did pull a knife at some point in the incident, which escalated the situation as well. Your Honor, again, our position is that Mr. Williams is the business, not to mention he signed the lease, and that this business can't operate, and it's threatening a large city contract that Mr. Williams has if he cannot be on the premises.
Well, let me ask you this: in terms of the emergency and the threat, while this is all very unfortunate, and I understand the identity that Mr. Williams has with his business, but this happened in early August, and Mr. Williams, I think, has been excluded from this property for the better part of a month and a half. I understand the argument that his contracts are endangered, but has Social Express continued to operate during that last month and a half? And if it either hasn't, or if there's been some limitation on its ability to operate, that might be more persuasive that there was some sort of emergency.
My understanding is that essentially Mr. Williams was excluded from the property for 3 weeks, in that he did his best to run the business remotely. His wife, who is a full-time Grady nurse, was basically using her off time to go onto the premises to help keep the business afloat, while he was excluded from the property. Your Honor,
let me make sure I understand. So when was he first excluded from because you say it like it's a closed window and that he's no longer been excluded. And my understanding is that exclusion continues now.
Legally, it continues now. Yes, Judge. There is still a trespass letter in place.
Okay. And so, I'm sorry?
Just, Your Honor, I didn't mean to interrupt. There's nothing in the verified complaint, nothing of any specificity about any of these alleged harms. I just want to
understand. Okay. Anything else, Mr.? So, Mr. Williams, I'll tell you like I tell everybody when they're in front of me. If you want to hear from me, you're welcome to address the court. It is absolutely your right to do so, but you have a very good attorney. And if you want to take a break and speak to them so that what you want to tell me can come through your attorney, that's usually best. Just because
I understand.
You've gone to the trouble to get an attorney, and your attorney knows what they're doing, and you should let them. They might need more facts from you, but you should generally let your attorney talk for you when you can. Okay.
Understood, Judge.
Okay.
Thank you.
Now, having said that, do you want to take a moment to speak to Mr. Garner, or?
Can we have a couple moments?
Sure, absolutely. Why don't y'all turn off your audio and video, Mr. Garner? Y'all can just call each other, and
That'll
I'm
work,
going to
Judge.
check on my criminal calendar, but this hearing is still going. We're just going to maybe take a 5 to 10 minute break, and yeah, let's call it 10 minutes, and then I'll be back. Mr. Garner and Mr. Williams, have y'all had a chance to speak, Mr. Garner?
We have, Judge.
Okay.
I'm actually would like you to hear from Mr. Williams' wife, if you're willing to hear 1 or 2 minutes of testimony. I think that
Sure,
might be,
Mr. Flake. I mean, it is a TRO, but I'm going to let you know in advance. I would like to know if you have any objection to 1 or 2 minutes of testimony from Ms. Williams.
I don't, and to the extent there is hearsay or other objectionable material, just in the interest of time, I'm just going to reserve my objections, but I don't have an objection.
Sure. Okay. Mr. Garner, you can go ahead. Ms. Williams, can you unmute the Zoom that y'all are on? Thank you. And if you'll raise your right hand. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Thank you, ma'am. Go ahead, Mr. Garner.
Miss Williams, why were you at the property on August 4th?
So I operate in the role of COO. That day we had meals. That was our first day back operating the contract. And so I was on site to train staff, help get food out.
All right. And you also have another full-time job, correct?
Yes, I am a registered nurse full-time at the hospital.
All right. Can you tell Judge Krause what happened when the resident approached you outside the service entrance?
Yeah, of course. So I was standing outside, one of my staff members, she was done for the day and she was leaving, we were just having a quick conversation. The resident, the older gentleman, as well as the younger man that you see on camera, approached me. The older man asked me, hey, can you open the door for me? In which I let him know that, I didn't know who he was. It just was a random person walking up to me. And I told him, I wasn't comfortable. I'm not supposed to open this door for anyone, other than my staff. And so he began getting hostile. Who said that? Who said that? I let him know that was, coming from the property manager. That's what I was told. And he began asking me, well, where is he supposed to go? I let him know there's a front door entrance that, everyone enters through. Again, began getting hostile, cussing me out. Okay. He said, okay, bitch, well, we'll see. I'll get this door open. I simply said, okay. I didn't go back and forth with him. He then made a call. And then you see the older woman comes down and she opens the door for him. Mm-hmm.
And then he gains access to the building, and then what happens next?
Yeah, so she opens the door. I don't say anything. I wasn't going to open the door for him, but if he got in, that was on him. So I didn't say anything about that. He gets in. I finish up the conversation I was having with the staff member.
I'm sorry, you broke. I'm sorry, ma'am.
Behind him immediately.
Ms. Williams, sorry to interrupt, but you broke up a little bit. I think where I lost you is you said,
can you hear
I can now. You just were broken up a little bit. So where I lost you is that you came in the door together, and then what happened?
As soon as I enter through the door, he immediately begins getting hostile, starts cussing me out. No, bitch, since I can't come in through this door, you can't come in through this door. Get out, get out. Began cursing me out. I immediately try to remove myself from the situation and get on the elevator. That's why you see me rush so quickly to push the elevator button. I attempt to get on the elevator, in which he's still verbally threatening me. I tell him to him, and then I proceed to try to get on the elevator, in which he's still cursing me out and attempting to now get on the elevator with me while continuing with the verbal threats. I say, hey, can I please get on the elevator by myself? Because I don't feel comfortable with you getting on the elevator with me. He still tries to force his way in. I put my hand up and I say, can you please wait? Our kitchen's on the first floor, so I mean, the elevator doesn't take long to come. I asked him, can he please wait? Can I just go up by myself? I continue to reiterate that, in which he continues to force himself onto the elevator. He begins trying to take pictures of me and, oh, I'm going to send you, I'm going to take a picture of you and give this to the property manager. He then proceeds to go around to it's a double-sided elevator. So he proceeds to go onto the other side of the elevator and push the button and it opens the door. He's able to get onto the elevator with me, in which he continues the entire time. He's still threatening me, cursing me out. Once he gets on the elevator with me and the doors close, he then goes, bitch, I'll punch you, bitch, I'll punch you, in which he has his fist up to me, threatening me in the elevator, and he pushes me while I'm in the corner of the elevator by the buttons. And in this moment is when I frantically call my husband, and I tell him, hey, I'm being attacked on the elevator. And he runs down. When I call my husband is when you see the resident flee off the elevator and he tries to escape. And so because I didn't know who this man was, I followed behind him to get a picture of him because I don't know where he's going. And I wanted proof of what happened to me. I don't know if the cameras work in the building or not. And I now know there's not even a camera on the elevator. And so I went after him to try to just get a photo of the gentleman because I didn't know who he was. And that's when you see my husband comes down the stairs and meets the gentleman in the at the bottom of the stairs there.
Thank you, ma'am. Mr. Garner, anything else?
No, Judge, that's all the questions I have.
Okay. Mr. Flake, any questions for Ms. Williams?
Yes, Your Honor. You mentioned, Ms. Williams, that outside the building, that you thought this individual was hostile and was using negative language towards you. Is that what you said?
That's correct.
You could have walked around the building at that point and used another entrance yourself, correct?
No, that's the entrance we use.
You could have used another entrance, correct?
I mean, could I have walked to the front?
Yes,
No.
ma'am.
No.
You couldn't have used another entrance to the building? Physically?
No, that is our entrance.
No. Did you have the ability to go to the front of the building and enter that way?
Not at that moment, no.
All right. Because you weren't physically able to? Is that why you're saying you couldn't walk there? It wasn't closed, was it?
The front entrance?
Right.
I'm not sure.
After these hostile words, you didn't call the property manager, did you?
I personally don't. I did not call the property manager. I don't have the property manager's number.
Right. And you didn't try to look it up at that point, right?
I'm sorry.
You didn't try to look up the property manager's number, did you?
I didn't, not at that moment. No, I didn't think I needed to. No.
And as we saw on the video, you walked in together with the resident into the building, right?
No, he walked in before me.
And you walked in behind him, correct?
I walked in after him, yes.
Right. So you weren't afraid for your physical safety, right? Because you followed him in. Is that right?
No.
Now, you opened the elevator. You didn't have to open the elevator, did you?
Yes, that was the only way I could get upstairs at the time.
You could have used the stairwell, right?
I believe I had some equipment with me that day, actually, that I couldn't
But you
care.
could have, ma'am, you could have used the stairwell, right?
No, I felt what I did was what I needed to do at the time. Tried to remove myself from the situation the fastest I could, which was get on the elevator.
And you didn't remove yourself from the situation when you ran after the resident, right? As we saw on the video.
In an attempt to get a picture of the person who attacked me.
Ma'am, my question was, you
Mr.
didn't.
Flake, Mr.
Yes.
Flake, you've made your point on that
Understood.
issue. You can move on.
Understood. The video appeared accurate, didn't it? You didn't. I mean, that's what we saw was what happened, Miss Williams, right?
Yeah. There are missing parts in the video that you don't see. You don't see him on the video attacking me at all. There's no video footage in the elevator. I'm the one who called the police about my attack. No one here is looking at me as the victim in this situation at all. I'm the one that was physically assaulted first. You don't see that in any of the video footage that you showed today.
It appeared in this one.
Verbally assaulted me. The video doesn't have any audio, nor does it have any footage of what happened in the elevator. The only reason I called my husband was because I was physically being assaulted, in which the man actually did have a pocket knife on him at the time of my assault, in which I didn't know. So this could have been, it could have went extremely bad for me. I was by myself in a situation where I was locked in with on the elevator with this guy. He could have, hurt me even than he did that day. So.
Ma'am, we saw on the video that there was probably less than 30 seconds in the elevator. Do you agree that we saw on video that you appeared to put hands on this individual in the elevator first? Is that what you saw?
So
No.
you see, no.
All right.
No. You
Your
see
Honor,
me put my hand up.
Your Honor, I don't have any further questions.
Okay. Mr. Garner, any follow-up on those questions?
No, Judge.
Okay. Thank you, Ms. Williams. Anything else, Mr. Garner?
No, Judge. I've just again, nothing in the lease allows this exclusion. I mean, this is completely a contract law. They are the victims in this case and are being treated like they're the aggressors. And this was a traumatic attack. She was harmed. This resident harmed her, and then on top of that, there's now a threat to their livelihood. And I would ask that you allow him access back into the building so that he can take care of his company, take care of his business. There's irreparable harm here, customer goodwill in this large contract, that can't be fixed with monetary damages, that could impair him ever being able to get a city contract again. And he has other customers as well. I would ask that you issue a TRO and allow him to resume. There's no threat to the community. And I would also stress to Your Honor, if there was a resident that attacked another resident, Integral could not just issue a trespass notice. They would have to go through process in order to either declare their lease in default and file for an eviction before they could remove the resident. It's the same here. You can't just issue a trespass notice against a tenant, especially against the tenant's basically sole agent. I think the case law is pretty clear about that. So I would ask Your Honor to issue the TRO.
Okay. So there are two things that I want to look at. No, Mr. Flake, you don't get to say anything else. I know you want to. There's two things I'd like, Mr. Garner. To the extent that the case law you're relying on is not already in your brief, if you would please email me a citation to, and Mr. Freehoff, when I say me, I mean Mr. Freehoff, email Mr. Freehoff the citations to that case law. Because obviously what I want to look at is, I suspect that part of the disconnect here from your client's position is that the tenant is Social Express, not Mr. Williams. And while obviously Mr. Williams is the principal member, if not the only member, he's certainly the primary individual or person who's operating that business. And I understand the interconnectedness of those things. It legally may matter. And so I want to look at those cases. The other thing, Mr. Flake, is if you would please email me, or Mr. Freehoff, the link to the video Now, I don't want anyone, particularly the Williamses, to think that I'm not particularly focusing on the video one way or the other, because it's just it's a capture in time, and I've heard testimony from Miss Williams about things that occurred that aren't on that video, and so I'll take it for what it is. And I, not in this context usually, but I am often called on to make a determination pretrial as to whether something was justified defense of self or others versus some sort of being the aggressor, et cetera, as the parties have argued. And so those are really the two things I want to look at. I'm going to look at those today. And then I will, understanding that this is an emergency relief that has been requested, I will probably have Mr. Freehoff email the parties either today or first thing tomorrow with what the court's ruling is going to be. And then we'll likely, depending on whose favor I rule in, will ask one party or the other to provide me with a proposed order. I will tell you, because of the nature of the relief, if I rule in favor of Mr. Williams, it will obviously be a very short window of time that Mr. Williams will have the benefit of any temporary relief until we can get a more fulsome evidentiary hearing with other witnesses, including potentially that individual that's also on the resident that's also on the video, and perhaps more importantly, information from the parties about the nature of the harm and Mr. Williams' ability to operate the business, or their expectation. So that's really what I'm going to be looking at if I rule in favor of Mr. Williams. If I do not rule in favor of Mr. Williams, it's going to be based on a finding that I've not found on an emergency basis irreparable harm in the exclusion of Mr. Williams. And that's what I'm going to be looking at. And I will give you, if you guys will email those two things that I've requested, I will review those matters and look a little bit more at the research that the parties have asserted, and then I will let you guys know what my ruling is going to be. Anything else, Mr. Flake?
On a housekeeping note, Your Honor, I believe I'll have a declaration that puts in that email from Ms. Judd from the Integral Group that I can submit
Okay,
today.
I'm certain that Mr. Gerner won't have any objection, given that it's communication between the two parties in the case. It would certainly be admissible and likely authenticatable. And so
Judge, I'm not going to make him go through that extra hoop. I'll save his client the 0.5 or whatever it would take for him to draft that affidavit. So I'm fine with it. I'm not disputing that it's not, authenticated or anything else. Mr.
Understood.
Flake,
Mr. Flake, I think his likelihood is that he just wants to make sure it's actually part of the record, so he'll probably do it anyway. Anything else, Mr. Flake, from a housekeeping perspective?
Yes, I just wanted to point out that I referred to Integral or the Integral Group, but because it's salient downstream, I just want to make the point that there are separate entities, Your Honor. So Ms. Judd actually works for a separate Integral entity that is the property manager, Integral Property Management, LLC. The partnership is an Integral affiliate that owns this property. The Integral Group, LLC, which has been named, is a holding company for the Integral Group. So if the case weren't resolved and it moved forward, we would certainly be looking to file a dispositive motion on that. But I wanted to, out of habit, I wanted to make a note that those are separate entities, and I was just using Integral for shorthand.
Understood. Mr. Gerner, anything else from your perspective, housekeeping or anything else?
No, Mr. Flake, if you would like to have a conversation today, I'm open to that.
Thank you, Mr. Gerner. I was going to suggest that the parties do that. And of course, if y'all have a chance to work something out, let me know before I send any emails that say this is what my ruling is going to be. Obviously, let me know as soon as possible if y'all have some resolution. Beyond that, I am going to leave it with you. Thank you both for your efficient and concise presentation.